Welcome to a new lecture in the RICS APC Essentials course. This course is crafted in order to help those who want to get chartered from the RICS under the quantity surveying route. The main aim of this course is to take your understanding of the different areas of competencies from level 1 knowing, going to level 2 doing, and then ending by level 3 advising. In this lecture we're going to be discussing conflict, resolution and avoidance. It's a mandatory area of competence up to level 1, which is knowing. However, because this area is quite important and there is a very decent guidance note from the RICS, we're going to be discussing this area of competence up to level 2, which is doing. In other words, we're going to be discussing level 1 knowing and level 2 doing for this area of competence. This area of competence is quite rich in terms of information, and we're going to be discussing a fair bit of points in relation to both levels. In level 1 knowing, we're going to be discussing an overview about disputes, and we're going to be shedding the light on some methods and techniques to resolve disputes between different parties. We're going to be also discussing how dispute resolution is tackled under different standard forms of contracts, and we're going to be shedding some light on regulations and reports here within the UK that are in relation to dispute resolution. And in level 2 doing, we're going to be jumping to how international commercial arbitration is tackled, in addition to the litigation procedures within the technology and construction court here within the UK. A dispute is simply a disagreement between the contractual parties, and that disagreement is not necessarily a breach of contract in itself. However, it might be one of the reasons that lead to a breach in the contract, which might give rise to termination of the contract or claims between the contractual parties, and that's where insurance companies might be involved. And now proceeding with level 2, which is all about the doing. International commercial arbitration is applied in the FIDIC, which is the most used contract globally. And one of them interesting cases is when a project is existing in one of them countries, so the law of the country of practice is going to be used for the interpretation of the contractual documents. And in our example, it's Indonesia. The project particulars, they included that the contract is subject to the English law, which means that the English law is going to be the main law that is used for the legal issues between the contractual parties, and the arbitration chamber might be existing in a third country or another country such as Singapore. So this means that the arbitration which is undertaken on this specific project in Indonesia will have to follow the Singaporean arbitration laws. And that is one of the classic arbitration complexities and why it could take more time than adjudication or the other amicable ways of settling disputes. Another thing is the litigation in the technology and construction court, and that's here in the UK. So it accepts a wide variety of them claim types or disputes that are related to construction, such as engineering disputes, claims against local authorities such as London Borough of Enfield or any other local authority, claims that are related to environmental matters such as pollution that is caused by a specific project or pollution that is caused by a specific practice in one of them construction projects, and also challenging arbitration. And that is one of the most important aspects. Although we have discussed before that the decision made by the arbitration is final and binding, however, it could be challenged in the technology and construction court. The judge in the technology and construction court will be responsible for the case management and summoning expert witnesses such as the quantity surveyor. They will make sure to keep records of the different proceedings of the trial as well as the date of the first case management conference. Once a decision is being made by the court, the winning party will be awarded the legal fees or the legal costs. Another thing to note in litigation, which could help pre-litigation, is called the pre-action protocol. This protocol is crafted specifically for construction and engineering disputes, and it's made specifically for disputes that are related to professional negligence if you're not doing the work properly. So the claimant or the party suffering from damage will issue a letter for the claim with all of them supporting particulars, and the other party or parties will have to respond within 28 days. And then the party suffering from the damage or the harm will have to reply to these points within 14 days. This is one of the methods in order to avoid going to litigation and to promote amicable ways of settling disputes. And this is all for this video, which is meant to be an extended trailer or a teaser. And if you want to have full access to the full length, the recorded videos, the notes, the presentations, and the question and answer banks, do not hesitate to get enrolled on the APC Essentials course on the APC Mastery Path web portal. And you can make the best use of a coupon code, which is APC35 for a 35% discount. All the best in your APC journey. Thanks a lot for watching, and catch you in the next video.